Hello everyone, this is Tom Fox and I would like to welcome you to episode 121 of the FCPA Compliance and Ethics Report. In this episode, it is part 2 of my 2014 FCPA Year in Review. I take a look at some of the greater trends, some of the concepts that the Department of Justice has communicated to us via opinion releases and statements, and where we might be going in the future of 2015. I hope that you enjoy the episode. It comes in at just under 20 minutes. Thank you. Hello everyone, this is Tom Fox and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. I'm continuing my retrospective look back at 2014, the FCPA Year in Review, and this is part 2. We're going to go and see how far we can get in part 2, what I want to start with, though, is to go outside the FCPA a little bit and talk about the globalization of anti-corruption efforts going forward. The GSK case was one of the largest or most noteworthy events of 2013, and in my opinion, it continued to be so in 2014. We had 2 trials around GSK, the GSK trial itself, and then we had the trial of former GSK investigator Peter Humphreys and his wife, Ms. Wu. GSK basically was found guilty in a one-day secret trial. It was not announced to the press. They were sustained a fine of $491 million. The country manager, Mark Riley, and 3 others were found guilty. They were all given suspended sentences, but at least the time of this recording, they have not been allowed to leave the country. So query what's going to happen to them going forward. This case, I think, is going to herald in one of the more significant events of 2014, and it may lead us to significant corruption and bribery enforcement across the globe. The key here is that the Chinese government was prosecuting GSK for a violation of Chinese domestic laws, not of the U.S. Foreign Corrupt Practices Act, the UK Bribery Act, or anything else. So we have a Chinese prosecution of Chinese domestic law around bribery and corruption. As many people know, the Chinese government is actively prosecuting its own citizens for bribery and corruption, and it's going to be interesting to see what the continued fallout for Western companies might be. But if you have business in China, you need to look very closely at that for a wide variety of reasons surrounding the GSK case and also for the Peter Humphreys and his wife's case. These were investigators who were hired by GSK in the middle of GSK's internal investigation after a GSK whistleblower had indicated to the company that it had paid bribes in China to obtain business. However, Mr. Humphreys and his wife were not asked to investigate the allegations of corruption and bribery, but unfortunately they were asked to investigate actual a sex tape that was recorded of the country manager Mark Riley and his Chinese girlfriend. They were hired to try and find out who planted the camera in Mr. Riley's apartment, who made the tape, and then who sent that tape to the GSK board in England. It turned out it was the same person that was the whistleblower who notified the company of allegations of bribery and corruption in China. Nevertheless, Mr. Humphreys and his wife were not told about the whistleblower. They were not told about the anti-bribery and anti-corruption investigation, and so they went off to investigate this sex tape. This investigation led to several prominent Shanghai families who were involved with GSK, and leading to the arrest of Mr. Humphreys and his wife in July of 2013. It was alleged that they had violated the Chinese 2009 privacy law. But that's all they were told, and then indeed they were not told what they were charged with till their day of trial in the first week of August of 2014. At that point, they were alleged to have obtained over 250 pieces of private information about individuals including government-issued identity cards, entry and exit travel records, mobile phone records, all of which apparently were in violation of Chinese law. As I mentioned, this trial was a one-day trial, and unlike GSK, it was not held in secret. It was originally scheduled to be held in camera, but there is a bilateral treaty between the United States and China which requires trials to be held in public, and the U.S. protested on this basis, so the trial was held in public. Originally, Mr. Humphrey's son was not going to be allowed to go to the trial. He was later allowed to attend. The couple was convicted of obtaining personal information, as well as government records on identification numbers, family members, real estate holdings, vehicle ownership, telephone logs, and travel records. So things that probably would be considered a public record in the United States, not available to you in China. This is going to be important, I think, in long run for many companies who try to do business going forward in China because of its implications on due diligence. Most compliance practitioners are well aware that in the 5 steps of third-party management under any anti-bribery or anti-corruption compliance program, due diligence is a key component. I break the 5 steps into the following: a business justification, a qualification questionnaire. Therefrom is due diligence and its evaluation. Number 4 is contracting, and number 5 is the management of the relationship going forward. But if you can't do due diligence, it puts a lot of pressure on the other steps. So if you can't do what the Department of Justice wants you to do in terms of due diligence, you're going to need to actively ramp up on these other steps, whether that be on your qualification questionnaire, whether that be on your contracting, but it's certainly going to be in the management of the relationship going forward. And indeed, I think GSK generally and the WU specifically would point towards a much more robust need for your management of your third-party relationships going forward. As to GSK, the saga continues for that company. The Serious Fraud Office and the United States Department of Justice are actively investigating GSK. GSK has internally reported corruption, that it's uncovered evidence of indicia of corruption in other countries, including Poland, Syria, other countries in the Middle East. There's still the ongoing issue of the whistleblower, and GSK may be in for a very long haul on this, so very significant. But there are other cases from other countries that I think bear reporting about in the year-end retrospective. Earlier we had SPM Offshore, and here it was the first time we'd seen the Department of Justice defer to Dutch prosecutors to permit the Dutch to enter into a $240 million settlement for that company's bribery and corruption. We had our first SFO prosecution of the Bribery Act involving a U.S. company, Parker Drilling, and its Scottish subsidiary, so that the company entered into an agreement in that case. And perhaps most significantly down the road are going to be 2 large investigations which have come out of Brazil. The first one is the Embraer case. That company has been under investigation in the United States for, allegations of payment of bribes. But now we have the Brazilian prosecutors also looking into the company. And now we've had the Petrobras case. And that one has really broken open, and that one may blow the top off Brazil in terms of its importance to the country, the politicians and high-level executives involved, and other facts about that case. There have been numerous, arrests and investigations. The United States Department of Justice has opened up an investigation into Petrobras USA. There have now been reports of shareholder derivative actions being filed against Petrobras USA. So that one is going to be very important for not only the country of Brazil, but also for a large number of other countries in terms of their actual enforcement of their own anti-corruption laws. We had a couple of interesting SEC actions involving some smaller companies and individuals, the Bruker and Timms case and the Reivew case. And these really revolved around gifts, meals, and entertainment. And in it, the SEC demonstrated why gifts, meals, and entertainment is a fertile source for bribery funding. Bruker, the company, paid $2.4 million for $230,000 in improper payments to Chinese government officials for gifts, meals, entertainment, and travel, obtaining suspicious collaboration agreements. The travel that was reimbursed was for leisure and focused on state-owned entity government officials who control contracting decisions. The Timms and Reivew matter was through a company, or employees rather, of a company called FLIR Systems, a defense contractor, and these gentlemen paid $50,000 and $20,000 respectively for improper gifts, meals, travel, and entertainment for Saudi Arabian officials. This included watches, a world tour for allegedly visiting FLIR facilities. Both cases involved expenses concealed with false book entries, fake invoices, and cover-ups. First time in quite a while we had seen the SEC go after gifts, meals, and entertainment charges against companies and or individuals. That also brings to mind the SEC's prosecution or enforcement actions, administrative procedures against Smith & Wesson and Lane Christensen. The Department of Justice took a pass and declined to prosecute both these companies. Nevertheless, we had the SEC going through their own internal administrative process to secure agreements with these companies not to contest the allegations against them. In the Smith & Wesson case, we had allegations of bribes and gifts in Indonesia and Pakistan, where there were payment of bribes, but it was not clear or was not tied together with earning of contracts. There were unsuccessful bribery schemes. Clearly, this case was meant to warn smaller companies with unsuccessful foreign market entry plans to ensure that internal controls were present and to ensure compliance. The Lane Christensen case also was an internal controls case, also where the Department of Justice gave a pass on the criminal side of the FCPA, but a failure of internal controls going forward. So I think that's going to be a significant lesson to be learned going forward, that the SEC is going to take a very close look at these internal controls, and that companies need to have internal controls in place. You need to have evidence of these internal controls, and you need to be ready to demonstrate that if a regulator comes knocking. I think these show that a clear SEC sophistication and that its expectations are increasing when reviewing compliance programs. That clearly the department and SEC know the difference between a real commitment and a paper program. A top-level commitment must be there. This internal controls focus, however, is new. Even if bribery is hard to prove, circumvention of these controls are not hard to prove. Either you don't have controls, you don't have evidence of controls, or you haven't audited against those controls. I think the COSO framework is going to be significant to this, and it's something that companies need to take a close look on going forward. Risk assessment and risk reviews of companies' operations cannot be done lightly, nor with a check-the-box approach. Due diligence and the management of third parties. I spoke a little bit about due diligence around the GSK in China, but I think it's going to be important that companies also manage their relationships going forward. On part one of this episode, or part one of my year in review, rather, I talked about one of the significant takeaways from the Alstom case, and that is in the area of merger and acquisition. We had two opinion releases. 1402 was one which detailed the steps a company needs to take when doing pre-acquisition due diligence. This was the first opinion release that the Department of Justice focused on the pre-acquisition component of mergers and acquisitions. So very good information, but clearly showing the department wants to see you engage in pre-acquisition due diligence as well as post-acquisition remediation. And the sort of the final point I'd like to leave you with is that ongoing monitoring, testing, and auditing of a company's compliance function needs to be ramped up and made more robust, because all of the deferred prosecution agreements had the following language. Ongoing monitoring, auditing, testing needs to be reviewed, but the key is taking into account relevant developments in the field and the evolving international and industry standards. I think this is something the department is going to start to focus on, that your program needs to evolve. And it really doesn't matter how close or how robust your program was when you initially implemented it. The department is going to be looking for evidence of what you have done to evaluate where your program is and what it's going to be based on evolving technological standards and evolving industry standards. So you need to take a look at it. You need to see where you are vis-a-vis your industry. And if you don't have technological solutions in place, this is going to be something that I think the department is going to take a dim view of going forward. And really the final thing I would like to leave you with from my review of 2014 in the FCPA and greater anti-bribery, anti-corruption world is what I call a business solution to anti-bribery and anti-corruption. It has become clear that many businesses are requiring that their contracting counterparties, i.e. those who are doing business they are doing business with, to have robust compliance programs in place. Scott Killingsworth has written on this, and he calls it private to private or P2P. And Scott has said the following, that embodied in contract clauses and codes of conduct for business partners, these obligations often go beyond mere compliance with the law and address the methods by which compliance is assured. They create new compliance obligations and enforcement mechanisms and touch upon the structure, design, and priorities and functions and the administration of corporate ethics and compliance programs. And these obligations are contagious, increasingly accountable not only for their own compliance, but for those of their supply chain. Companies must seek corresponding contractual assurances upstream. Compliance is becoming privatized, and privatization is going private. I have seen this certainly in the energy industry, where if you want to do business with a larger company than yourself, you're going to have a compliance program in place. And you may be audited on that program. You may have to show that program to any of your contracting counterparties, and you may be required to do the same for companies downstream of you. Certainly we've seen this in the finance industry, where banks are requiring companies to covenant that they have best practices compliance programs. Banks are auditing companies for their compliance program. In the private equity world, if you want to access money through that secondary market, you're going to have a compliance program. If you want to go public, you're going to have a compliance program. So in addition to the accessing of your cash, which we had previously seen, we are now seeing this in the business contracting solution that most companies are engaged in on a routine basis. So this may be the biggest driving force behind anti-corruption and anti-bribery compliance. When you have to have a compliance program in place to create a contract, that is something that companies pay attention to. This concludes my two-part retrospective of 2014. I hope that you have enjoyed it. You can contact me at tfox@tfoxlaw.com. This is Tom Fox, and thank you very much for listening.